All right, Mr. Cooney, the defendant, as I understand from our conversations at the beginning of this procedure, has the burden of proof. And how does he want to proceed?
Your Honor, we will just simply treat it as a motion rather than a substantive trial. So what we're going to do is, with the court's permission, Mr. Scheck and I will both address the court in a brief closing statement, let the state respond, and to the extent we feel we need to further respond, we might ask for a brief rebuttal, but we might not.
I think I want to say something before you start. You know, I've been a trial judge for a long time. I was a trial attorney before that time. I always thought that the procedural device, the motion for appropriate relief, was one of the more important devices that a criminal defendant could use to obtain justice. And I was fortunate enough as an attorney to use that to get justice for people wrongly convicted. I've been fortunate enough as a judge to participate in cases involving you where justice was achieved. I looked at 15A 270. You and Mr. Scheck have practiced law all over the United States of America. I have not. 15A 270 is one of the more amazing statutes that I have ever seen in my life. It deals with scientific, technical evidence. It clearly deals with Mr. Howard's case. I've never seen a case that's been applied directly to do what you are attempting to do today. That statute was pointed out to Mr. Howard and to his counsel and to the state in the prior decision where they reversed my judgment, but they indicated to Mr. Howard that there was a pathway, this is the way I interpret it, a path that he could have achieved to seek relief. You may have known that that's the way you have to introduce the DNA, that there had to be a separate hearing. If you did know it, you didn't do it right the first time because they told you you need to go back and make it a separate motion, separate and apart from your motion for appropriate relief, which you have done. If the wording in that statute means what it says, that statute can be a tremendous mechanism for justice in the appropriate case. And what I want you to do today is to tell me why you believe that that's correct, because I know you believe it. So tell the public about 15A 270, because a whole lot of people don't know about it.
I'd be happy to, Your Honor. 15A 270 and 269, in response to that, is a remarkable statute, because what it does is it gives a defendant the right to use science in the advancing state of science and technology to revisit cases that ordinarily you would not be able to discover evidence on, you would not be able to deal with. And what it does is it permits a defendant to seek DNA testing of evidence from an old case where the defendant avers that he's innocent, which he has, and where the court finds that it's more likely than not that if the DNA evidence is tested and the results are favorable, that it would result in a different outcome for the defendant or show the defendant is not guilty of the crime. And that's the application part of the statute. The remedial part of the statute, which is what Your Honor has specifically referred to, is even more remarkable.
It's even more amazing.
Because the remedial part of the statute simply says that when the DNA results come back, the state is entitled to a hearing on whether or not those results are favorable. And if the court finds those results are favorable, the court has any number of options, including and up to dismissal of the underlying charges, but certainly including a new trial or any other relief the court deems appropriate. And the remedial part of the statute, when it talks about DNA results being favorable, that clearly holds within it evidence that stems from the DNA results themselves. It's not just simply a mechanical thing of, here's what the DNA results are. But if evidence naturally flows from it, the court is entitled to take that into account in terms of determining what favorability is. There has been no Court of Appeals decision interpreting what favorable means, as we talked about at the beginning. I think you can make a strong argument that favorable means something different than a reasonable juror would have a reasonable doubt. That it can mean something less than that. That it can simply mean the court finds it's favorable or not. But I think we have agreement that the standard is no higher than whether a reasonable juror would have a reasonable doubt. There have been no case law on this because one of the other interesting things about this statute is it doesn't provide for a right of appeal for anyone from a determination on whether the DNA evidence is favorable or not if a new trial is ordered. Or if a new trial is not ordered and the court finds that the evidence is not favorable. There is a Court of Appeals case directly on point where the Court of Appeals says the General Assembly didn't provide any vehicle for that. So, in effect, the General Assembly has given defendants a right to take advantage of science and the way science progresses. And they have vested in superior courts the discretion to hear this evidence, to determine whether it's favorable, and to grant the appropriate relief, and effectively do so as a court of last resort, which is how this court now sits. Because this court is Mr. Howard's last chance to avoid spending not only another day in jail, but the rest of his life in jail. And as you point out, he is taking advantage of the statute. We actually did plead the statute in connection with the motion for appropriate relief, and the Court of Appeals pointed out that it believed it needed to proceed separately with a separate hearing, which is why we filed a separate motion on that. But this case actually started, everything you've heard and everything you're going to hear, actually started with 15A-269, that remarkable ability for a defendant to apply to a court to say, I'm not guilty. There's physical evidence there. We now have the science to know what that means. Let me test it. Now, if Your Honor would like, I can continue on into the closing.
All right.
Thank you, Your Honor. So, when we talk about favorability, and you heard Ms. Ellis in her opening statement say favorability, whatever it means, has to be measured against the case that was posed against Mr. Howard back in 1995. in light of what we know now. And so what I'd like to do is talk a little bit about that. And I want to begin where I began the opening statement, which is Mr. Howard at his trial and as he was being sentenced and after the jury came back repeatedly said, I didn't kill those girls. I didn't kill those girls. I didn't kill them. I swear to God I didn't. I didn't kill them girls. I didn't do it. And for 25 years he's fought to show that he didn't kill those girls. Now, Ms. Ellis at various points has suggested that somehow we've got to present conclusive proof of exculpatory evidence. And of course that's not the standard. But Your Honor, we've come about as close as you can in what we've presented in this DNA evidence. And I think when you compare it to the case the state had in 1995 and what we know now, it's very hard to say this hasn't been close to conclusive proof of exculpatory evidence. So what was the case against Darryl Howard? Well, it consisted of 6 witnesses. These eyewitnesses the state keeps referring to, there were only 6 of them. Their names were Renuka Jackson, Rhonda Davis, Terry Suggs, Kevin Best, Dwight Moss, and a woman named Angela Oliver, who's sometimes referred to as Angela Sutter. What did they say? Well, Renuka Jackson said that Mr. Howard argued with Doris Washington during the day on November 26th, the day she was murdered. Threatened to kill her. And then she said she saw Howard and his brother leaving Doris Washington's apartment with television sets. Plural. They each had a television set in their hand. Of course, as you know, we've introduced the crime scene photos that show the television sets were in the apartment. There wasn't an inventory presented. There wasn't a single piece of evidence that said a television set was missing. But on top of it, Ms. Jackson was contradicted by the state's next witness, Rhonda Davis. Because Ms. Davis said she was with Doris Washington all day on November 26th from 10:30 a.m. to 10:30 p.m. and she never saw Darryl Howard. He never threatened her that day. He never threatened to kill her. So the state's first witness says, oh, well, he was there that day and threatened to kill her. The state's second witness says, no, I never saw him that day. So you can't believe them both. Life doesn't work like that. Terry Suggs. Mr. Suggs says he saw Howard and a woman in the vicinity of the crime at about the time the fire trucks came. Well, and he says Mr. Howard wasn't carrying anything, had nothing in his hands. Of course, the problem with that is Mr. Howard admitted he was in the area on the night of the crime with his girlfriend, Natasha Mayo. The fact that Mr. Howard is seen in the vicinity of the crime isn't proof of anything. He was there to buy drugs. The fire started, he had just bought drugs, he had drugs on him, he had a trespass order against him at Few Gardens, and he figured, I probably shouldn't be here when the police and fire trucks come. But the fact that he is seen in the area of Few Gardens is not a surprise. He admitted to it on the witness stand. That inculpates nothing. So their next witness, Kevin Best. Mr. Best says he sees Howard and his brother, not a woman, but Howard and his brother, carrying a television set, and now we have a VCR too. So they're carrying both a television and a VCR. And of course, television sets are still in the apartment, and there's no evidence whatsoever there was a VCR in the apartment. And in fact, in this picture, and it's difficult to see, but the one we have in evidence shows there's an electronic device, might be a VCR, in that chair just across from the television set, still hooked up to cables. Except the police never bothered to collect it. They never bothered to take any measurements of the dust patterns. They never bothered to do anything. And then we have Dwight Moss. Mr. Moss says He was there, and Mr. Howard threatened to kill Doris at 4 p.m. on the day of the murder. Well, remember, and then he says he sees Howard and another man, not Howard's brother, but another man, carrying a television and a VCR. Well, again, we know the TVs are there, but we also know Rhonda Davis says she was with her the whole day and never saw Mr. Howard, and never saw Mr. Howard threaten her. And finally, we have Angela Oliver. Ms. Oliver is the only one who puts Mr. Howard in Ms. Washington's apartment with the intent to do something to her, according to her tape-recorded statement. The problem is, she recanted that statement on the witness stand. She said she was pressured to give it. She said she didn't know anything about a murder. She said she wasn't going to testify to things she didn't know about. The state actually had her arrested and put in jail before her testimony as a material witness because she wasn't testifying the way she was supposed to, and she continued to recant on the witness stand. So that's what we have. We have witnesses who are telling stories that do not fit together and cannot fit together, and one witness who actually recants on the witness stand. That was the state's case. And you know what? Mr. Nifong recognized it at trial, because this is from his closing argument. He talked about what Mr. Van wants. He wants you just to say, how could we not have a reasonable doubt? These people don't all agree. They don't all say the same thing. The defendant never confessed. All of that is true, ladies and gentlemen. And Mr. Nifong went on. Now let me stop just a second before we get into this and talk about inconsistencies. Have there been inconsistencies in testimony with respect to exact details, such as times and things like that? Yes, there has. And the way Mr. Nifong tried to explain it is, well, you know, 5 blind men who've never seen an elephant were each feeling a different part. One feels the trunk, one the side, one the leg, one the tail, and they all think the elephant is something different because they have all seen only part of it. That's what we have in this case, ladies and gentlemen. Mr. Nifong is saying his witnesses are like 5 blind men trying to figure out what an elephant is when they've never heard it. Now they convicted Mr. Howard. She's exactly right. And the Court of Appeals said that evidence was sufficient based on what was presented at that time. Didn't say it was compelling, didn't say this was overwhelming. It was sufficient, based in part on Angela Oliver's tape-recorded statement, which she recanted, which could never be introduced now under Crawford because it violates his Confrontation Clause rights. Because Ms. Oliver gave a statement that no one got to cross-examine, no one got to challenge, and according to her, a 7-minute tape took 45 minutes to make because the detective kept stopping the tape and telling her, that's not right. So that's the state's case. It was sufficient, I submit barely so, in 1995. What you need to do is determine the evidence the jury did not have as you consider whether this DNA evidence is favorable. And we're just going to look at the DNA evidence and the evidence that flowed directly from the discovery of the DNA. And Your Honor, this is where I have to say this proceeding has been remarkable. Because when we filed this motion after the Court of Appeals decision in June, all we knew was Jermac Jones' DNA was found inside Doris Washington. We had experts, of course, saying that that proved there was sexual assault. We didn't have Mr. Jones's interview. We didn't have the things that have flowed directly from his interview. We only got those once we proceeded to hearing here. So let's look at the evidence the jury did not have in 1995 that we know now because of the DNA. I'm going to just touch on this very briefly because Mr. Scheck's going to address it in more detail. We know we have DNA from Doris Washington. Jermac Jones's, and it was an unidentified male, and the identification came back to Jermac Jones. His sperm inside Doris Washington. 1 in 20.7 billion chance of that being a random match. Jermac Jones makes false statements. He made some of them to Mr. Waller. We had no idea. He had made the same statements to the police 5 years ago, or similar and additional false statements. Jermac Jones makes statements indicating he knew what happened. When he's on his phone, he talks to people about not ratting people out, and they're going to have to get me a lawyer before they learn anything. Then he comes into this courtroom, Your Honor, and he takes the Fifth Amendment. And I've been practicing law a long time, don't have Your Honor's experience in terms of numbers of cases, but that was a remarkable thing in my career. A man who's been convicted and has served 25 years based on no physical evidence sits here and watches another man whose sperm is found inside the dead woman take the Fifth Amendment because whatever he's going to say is going to incriminate him, and he gets to walk out the door. And Mr. Howard gets to go back to jail. And that's what makes this statute remarkable, Your Honor, because you can do something about that. Because everyone in this courtroom, everyone knows that's not justice. And then the DNA results showing us two different men corroborate the confidential informant's tip, that there were multiple perpetrators. All this is flowing from the DNA. And in addition, Howard's DNA can't be found. This is the most sensitive testing we have. A nanogram of DNA will show up. It is inconceivable. Mr. Howard could brutalize these women, rape them, strangle them, beat one of them to death, shove an object up inside one of them by himself and not leave a nanogram of DNA. And that's what Dr. Miller said. Not only is there no evidence that Mr. Howard was there, all the evidence is he was not there. And then, what you heard finally through Mr. Waller is Jones claims he had sex with Nishonda the night before her murder. The state's embraced that. He's the boyfriend. Isn't that possible? Except his DNA is not in Nishonda. That means either he's lying about that, which also inculpates him, or if he's telling the truth, he has just proven another man came in and sodomized this child between the night before her murder and the night she was found dead. And that man's the killer. Because you heard evidence that semen, because the sperm was intact, was deposited less than 24 hours before it was collected. So it had to be done after 10:30 in the morning on November 26th. And then we go back to something else Mr. Nifong said in closing. Remember, he said, consider this, ladies and gentlemen. You know, despite the fact that this case was never investigated as a sexual assault, which we now know not to be true, and it was never suspected as a sexual assault, which we now know not to be true, Mr. Van wants to make it a sexual assault, and why? Because he knows the defendant never had sex with Nishonda and Doris. So if he makes you believe the killer was somebody who had sex with them, then obviously it couldn't be the defendant. Mr. Nifong posed the issue. If there was a sexual assault, then Darryl Howard's innocent. That's what Mr. Nifong told the jury. That was the state's position at trial. You've now heard expert testimony from a forensic pathologist and a forensic scientist that there was a sexual assault, that both these women were sexually assaulted, that in particular Doris Washington, the presence of that vaginal laceration in combination with the sperm proves she was sexually assaulted. And if that's true and there's been no rebuttal to any of that, Mr. Howard's innocent. Mr. Nifong said so. I'll go ahead and turn the rest of my time over to Mr. Scheck, if I may.
Your Honor, I thank you for the permission to appear in this court. It is an honor, sir. The statute that we're talking about, I must say that my colleague and partner, Peter Neufeld, and I began what's known as the Innocence Project in 1992. And when we started, there were only 2 statutes in the United States. In New York, which we hope get passed, and in Illinois, that allowed for post-conviction DNA testing. Now, the federal government, Congress, and all 50 states have these statutes. And the reason for these statutes and the remarkable breadth of them is this miracle, this scientific miracle of DNA testing has transformed the way we look at the criminal justice system, and it is a recognition that this kind of evidence in old cases can trump memory that tends to fade and all kinds of infirmities in the proof that happens when we go back and look at old cases. And now there are, I think, 56 innocence organizations.
60, more than 65.
More than 65 innocence organizations. That's Professor Newman from Duke, who's helping me there, that are engaged in this work. And I have to say that law enforcement, and prosecutors' offices are engaged in this work with conviction integrity units that actually work with innocence organizations and defense lawyers once there is new evidence of innocence, whether it's DNA evidence or some other kind, to reinvestigate. And I say that because that's very relevant to what happened in this case. Now, in terms of the DNA evidence, this is not just what Mr. Cooney pointed out, is that we now know whose semen is in Doris Washington. We now have some further results from Nishonda Washington. It is new evidence, particularly that it is not Durham Jones's DNA. And if you want to engage in this supposition that he is her boyfriend, as Mr. Cooney pointed out, that's very, very powerful. But in addition to that, we have this CODIS hit. And what should happen after a CODIS hit is an investigation. It's common sense of the person whose semen is found in the murder victim. That's the way it's supposed to proceed. And unfortunately, in terms of a conviction integrity process, in terms of a reinvestigation, this wasn't so great. So first, the sperm of Durham Jones is in Doris Washington's vaginal swabs, and we had expert opinion about how that relates to it being a sexual assault. None of Jones's DNA is found in Nishonda Washington, and we had that very powerful testimony from Dr. Roberts and the others that if you take Rhonda Davis's testimony seriously, and Nishonda was going up to take a bath, and even if you want to indulge in the notion that it was a shower, certainly, and if you assume for the sake of argument, and I don't know whether the state is going to take this position, but even if you assume that it was Durham Jones that had sex with her the night before, right, but then she takes a bath or she takes a shower, you have intact sperm. Sperm with heads, sperms with tails, which everybody knows is of a recent deposit. And when you add in the shower or the bath, it seems pretty clear that the weight of that DNA evidence now clearly points to it being left by somebody that was engaged in a sexual assault of Nishonda Washington and Doris Washington. Oops. Now, Mr. Jones took the Fifth Amendment to, of course, all the key questions, whether he had sex with Doris Washington, he was involved in the rape murder of Doris Washington and Nishonda Washington, and this court is allowed legally, as any fact finder, to draw an inference from the fact that he took the Fifth Amendment. But you have much more in this case. It's unbelievable. He didn't just take the Fifth Amendment. We now have this videotape where he gave several false exculpatory statements to police investigators. And my God, isn't that what law enforcement and police and everybody looks for in cases when you catch somebody red-handed with forensic evidence that can't be disputed, and all of a sudden the person begins to tell you lies. And he is overheard on this recording, not just telling lies directly to Sergeant Penica and Investigator Susie, but he's overheard making phone calls to people that demonstrate guilty knowledge, guilty involvement, consciousness of guilt about these homicides. Because it was a secret camera and he didn't know it was there. At the very beginning of the tape, you see him looking around for a camera, but obviously he didn't know it was there, and he was being recorded. Now, so, 2 different male DNA profiles from sperm in the victims. Neither is Darryl Howard. And we've got to remember that Mr. Nifong's opening statement and his closing statement in this case, he said there was one perpetrator. No sexual assault, and one perpetrator who did both of this, Mr. Howard. Now, the DNA evidence alone provides extraordinary proof, corroboration of the defense contention that there were 2 perpetrators, right? We now know there was a semen donor, Jermac Jones, and his semen is in Doris Washington around the time of her death. And we know that there's the semen in Nishonda, Washington. At least 2 people were involved here. That corroborates the defense theory. It knocks down the prosecution theory. That in and of itself would give a reasonable juror reasonable doubt. Supports the defense argument at trial. Now, one of the things that we focused on here is that we know November 27th is the murder, December 1st, 1991. Well, we also know that what happens is Detective Doughty, talking about not suspecting or investigating it, asks people in the crime lab to do a cocaine screen, but he also asks for vaginal swabs. He wants sexual assault kits done. Then we have a statement from detectives, from Captain Sarvis in the press, saying it's undetermined whether there's a sexual assault. And then this key memo. On December 1st, 1991, to J.T. Muse from Pratka, who is patrolling the streets in Kew Gardens in the area, is beat. And it says, reference double homicide, arson, Kew Gardens. Informants advised me that subjects were probably murdered because mother owed $8,000 to drug dealers from either Philadelphia or New York. The informant stated that many residents in Kew Gardens were offered $2,000 a week for the use of their apartment, but apparently not many accepted. Informant further stated that perpetrators, more than one, perpetrators were believed to have left 4 bags of drugs in the apartment and apparently found some contents missing when they came for them. The perps then told the victim tenant she owed them $8,000. When the perps came for the money, they first raped her. They first raped Doris Washington before strangling her. The 13-year-old daughter may have unknowingly walked in on the scene, so they then killed her. Now, what's extraordinary about this, it's fresh information from an informant right after the incident. It's what all law enforcement, as Susie herself indicated, it's incredibly specific. It corroborates everything that was coming out at the trial, that this was related to Doris Washington selling drugs, that she was known to commit acts of prostitution in order to buy the drugs. Everybody agrees that was the state's theory too, that whoever killed her was killing her for revenge because she owed money to drug dealers. But the key thing is the semen. That's the real identifier of who committed the crime. And here, Detective Doughty realized this. He says, there may be something to this. I don't remember any public info on the rape. That's Captain Sarvis, who's in charge of Doughty and everybody else in the investigation. The spokesperson who said it in the press. This is a holdback fact. This is one of those facts that the police or the don't reveal to the public. So if an informant like this comes forward and it turns out that there was in fact a rape, then that gives you greater confidence that all this other specific information is true. Now, admittedly, at this first trial, nobody had the DNA evidence that Doris Washington had seen in it. I mean, it was pretty clear that she was sexually assaulted by a sharp instrument, but they didn't have the semen. They didn't have the DNA result. We have that now. And that, in any retrial, the jury would look back at this lead that was not pursued. Indeed, as the record reflects, you know that in the MAR proceeding, the contention is it was never disclosed. But putting that aside for a minute, in a retrial, this lead shows that the holdback fact that there was a rape is in fact corroborated, and all of a sudden, all the information here takes on greater reliability. That is, as even Investigator Susi admitted, how law enforcement thinks about it. And it's logical. You look at it when you're evaluating a confession, you look at it when you're evaluating an informant. If the forensic evidence corroborates things that only the police and the real perpetrator would know, then all of a sudden this information looks more reliable. And what is this information? This information is that the perpetrators, this information is that it's the New York boys, it's the entire defense of Mr. Howard. And this memo is his defense. And now we have new forensic evidence that corroborates what was a holdback fact, that there was in fact a rape, that he didn't have at the time of trial, that he has it now. And I think that is overwhelming proof of innocence when you put it in the context of this memo. Even assuming it was disclosed and nobody used it, which makes no sense in the context of this case, in a retrial, this memo would be devastating. And it would be a big question as to why didn't they follow up on this lead? Who is that person? What did he know? And it's not good enough to say, well, now that we have all of this and we have the DNA, all these years later, we're going to go out and find that person. Ridiculous. Should have been turned over then. But now, a jury would take a look at this and go, oh, there's a lot to this. As Doughty said, there may be something to this. And now we know because of DNA testing, there's an enormous amount to it. Intact sperm, we had testimony. I don't think we really need to go over it again, but that shows it's a recent deposit. You put that together with the testimony of Rhonda Davis about the bath or the shower, it doesn't matter. It makes it much more likely than not that the semen in Nishonda, Washington came from an attacker. It was a recent deposit. And we've been through this, that Jones had sex with her the night before. But if that's true, his DNA is not there, right? So that means it was a second perpetrator, besides the person who killed Doris, which I think the physical evidence shows that Jermac Jones was involved in that. And where is the boyfriend? And this is one very, very troubling part of the case. Because we see in the record that Detective Doughty says that he spoke to a boyfriend who said that he was having sex with Nishonda Washington, or his investigation revealed it, but he certainly is indicating that he spoke to this boyfriend and knew that she was out of the home and had only come back before the time of the murder. Well, if that's true, and you're interested in the truth and you're investigating the case, then don't you go out and get DNA from the boyfriend. Even in 1991, it's not like the technology was any different. In 1991, you can get the DNA from the boyfriend and you can test it, and if it's not the boyfriend's DNA, well, that's good evidence for the defense. On the other hand, if it is the boyfriend's DNA, then Darryl Howard's defense goes down the tube. His lawyer got up and said, you know, the fact that his DNA is not in Nishonda in and of itself creates a reasonable doubt in the opening statement. But if you go out and get the semen from the boyfriend, it comes from the boyfriend, and you can prove that it was a consensual partner, case is over. And by the way, if you're really interested in the truth and you're engaged in square, fair, straight-up law enforcement, that's exactly what you do. That is exactly what you do. And it wasn't done here. Now, of course, the defense, they don't have the name of this mysterious boyfriend. They don't have his identity. They can't go out and go to a judge and ask to have a sample taken so they can demonstrate that the prosecution's theory is no good, or just go out and get it. But that's not a mystery. We knew all that in 1991. 1989, when DNA first came into court, it's common sense. But that's why the new DNA evidence and this claim of Durham Jones that he's the boyfriend and the semen isn't there is such powerful evidence. And by the way, it's very clear that there was abundant amount of semen, talk about recent deposit, because we know RFLP testing required a lot more DNA. And so there was a lot more DNA in Nishonda's anus and in the vaginal vault to get a result with an RFLP test in 1991. That was the testimony of our DNA expert. Now, following up on these phone calls, I mean, I really thought that I was disappointed to hear Investigator Susie testify today that she didn't think, I thought yesterday she conceded that when she was watching what Durham Jones was saying, she didn't believe him. How can anybody believe him when he says, I don't know Doris Washington, when in the biblical sense she plainly knows him. Plainly knows him. It's his semen in her. And watching all those telephone calls back and forth. She said she didn't look at that tape. Sergeant Pennick, I mean, it seems pretty clear he must have at least seen the tape. There's that moment where Jermak's on the phone and he says, they ain't going to hear nothing from me about what happened until I get my attorneys. And he all of a sudden comes back into the room and says, who's your attorney? Certainly, the inference can be drawn that he's watching that conversation. He's going back and forth. But the real point here is these telephone calls are devastating evidence. And the failure to disclose this in a timely fashion. I mean, this court issued an order on September 15th, 2011, saying you got to tell the defense the identity of the individuals and any information that you have about that individual. And they are sitting on a recording that any minimally competent investigator, if they take one look at it, if they are all interested in following up on this case, right, and finding the real perpetrators, as opposed to, for whatever reason, saying, we're just going to preserve this conviction, right, you would follow up on it. And if they had disclosed that recording to us in 2011, as this court ordered, right, then we would have looked at it. We would have brought it to the attention of our colleagues, and I'm pointing at Mr. Morrill here, who was on the case at that time, and we would have said, hey, take a look at this. You should go find who he was talking to on the telephone. Let's get a warrant. Let's do a reinvestigation. If you don't do it, we'll do it. Now, one document that we put into evidence here, and I say this out of fairness to our colleague, Mr. Morrill, who was on the case at that time, because it's not in dispute that we were talking with him. That's why we got the order from the court. We wanted to do a conviction integrity review, and we notified him when we were going to talk to Durham Jones, but allowed him to do it first. If we had seen that tape, we would have come back here, we would have gone to them, and we would have made all the obvious suggestions that we've made during this hearing. But we didn't get that until just weeks ago. And Even the investigator who took the statement said she didn't even see it until like, I don't know, what was it, Friday? The point is, a new jury is going to know all of this. And a new jury is going to have to say, well, if the defense or law enforcement had looked at this tape and gotten his phone records, had done what any serious investigation would entail, they would have gone out and gotten new information, and maybe we could have broken this case wide open. That is how it should have been done. That's what an argument would be to a new jury. I think that's absolutely self-evident. And what is disappointing, and I put it in the record because, in fairness to my colleagues, is that the former prosecutor, Tracy Klein, ordered them not to investigate. And that's why it's kind of crazy. I think they were sort of investigating anyhow. They certainly got a search warrant indicating they were. But that's why that happened. And apparently, if we believe all these witnesses, that's why none of the people on the state's team knew about this devastating, devastating recording. And while that may be the way it happened, and it was, I don't know how you want to characterize it, negligence, it was something that should have been disclosed to us pursuant to the court's order. And I would even argue that there is a post-conviction right when you're investigating innocence to make sure that material evidence of innocence is disclosed. And there is an ethical rule from the American Bar Association, 3.8G and H. 3.8G says that material evidence of innocence that the prosecutor knows about should be disclosed, and 3.8 G and H says that if there's clear and convincing evidence of innocence that a prosecution knows about, they got to do something about it.
Well, maybe that's why she's no longer a prosecutor.
I'm sorry?
Maybe that's why she's no longer the prosecutor.
I couldn't help but note that we have a prosecutor who tried this case, who's disbarred, and we have a former prosecutor who ordered no investigation, who's also disbarred. No small irony. Okay. And we all heard it yesterday. Look at these statements he's making. First he says, Doris was my girlfriend. Then he says, I don't want to talk. Let's see. I don't even know fucking Doris Washington when his semen is in her. His daughter, her daughter was my girlfriend. And you remember then on the phone, as Mr. Cooney pointed out, he's talking to, he says, the other Shonda. And I was glad that it was brought out through Mr. Waller that Mr. Jones's girlfriend, when he interviewed her and she was present, is named LaShonda. So the inference seems pretty clear that if you got the telephone number, he was talking to LaShonda. But he's saying, even if he weren't, he's talking about the other Shonda because he's dating a LaShonda. You remember the other Shonda and her mother? They used to stay over there in Kew Gardens. He plainly knows them. And then at another point, he said that he'd been to Shonda's house. And then he's saying to them, I didn't even know Doris, but it's plain from his conversations that he does, and that he lived right up the street. So, yeah, that's the statement about, remember we used to be over at Shonda House, and yet he's telling the police and Jerry Waller he'd never been there. Okay. This is guilty knowledge, as clear as you can get it. He's calling somebody on the phone, I don't know if it's Vernon or Vera or whatever, it doesn't even matter. And he's saying, I don't want to rat on anybody. I don't want to rat on anybody. And it's very clear through all those conversations, he's telling people, don't worry, I ain't talking. Don't worry, I ain't talking. And at the end, of course, he's finally saying, because the law enforcement officials, both Susie and Pat, are going in there and they're saying, hey, maybe you just had sex with her, but you didn't kill her, and they're suggesting all of this. Oh, we don't think you did it, right? Somebody else did it. Talk to us, talk to us, talk to us. We want your side of the story. They were plainly doing that, plainly encouraging them to come in with an attorney and give them something and cooperate. And he has something to say. He knows something. He obviously knows something. He was involved in these homicides. It's as clear as day, or there's certainly probable cause to believe that, and go get his phone records. It's obvious. And he's, of course, obviously distressed, talking about things can't go, no work. And I've already been through that there was no follow-up here, that they could have broken the case wide open. So, Your Honor, I thank you for your patience in this. It is an extraordinary statute in terms of your ability to give relief. There are different standards in all the post-conviction DNA statutes across the country. It seems pretty clear that favorable, as Mr. Cooney pointed out, could be a lower standard than a reasonable doubt that a reasonable juror would have. The more traditional standard for vacating a conviction, we more than meet the traditional standard. I would argue on this evidence, we probably meet a clear and convincing evidence of innocence standard, but that doesn't matter. We've overwhelmingly met our burden, and we would ask the court to rule in our favor on the DNA application.
All right, Ms. Ellis.
Thank you, Your Honor. Your Honor, with respect, counsel, and to Your Honor, I'd like to just make a few closing remarks on this and just state that we don't really have a dog in the fight. We're looking purely on the record when we're looking at MARs. We're purely looking at the record. We're purely looking at the law. And here, the law and the record show that the defense has not proven their burden. The materiality in this case has been looked at by the courts, and DNA evidence alone in isolation cannot be looked at to determine automatically that it's material, with that meaning that just the presence of this material does not alone make Mr. Howard innocent. Instead, it must be judged after comparing it to all of the evidence produced at trial. And if we look at State versus McLean, that kind of goes to that premise, and that was a 2014 case. I believe it's State versus McLean, 232 North Carolina App 111. If we look at North Carolina case law, State case versus Ovander, the defendant there was accused of rape and incest and ultimately convicted as he pled guilty to that. 10 years post-conviction, they filed a motion requesting the DNA testing in that matter. However, the SBI did not find sperm on the victim, nor incriminating DNA of the defendant on the victim whatsoever. No physical evidence, none. This was a rape case that he pled guilty to, that he asked for testing. No evidence was found. The plea, however, was based on the victim's injuries, the victim's statements, the victim's ID of the defendant, corroborating statements made by other witnesses. In that case is pretty analogous to this case because it's consistent here with the jury's view of the evidence, the facts, the testimony, and all of that corroboration was something that the jury got to look at. He's stating that you can take out one or two or three of the individual's testimony and therefore the whole case comes crumbling down. But let's look at that. During the state's trial, the state presented 14 witnesses. The first was Wesley Mclaughlin, who stated at the time of the crime was a hazardous response specialist with the Durham Fire Department, and that's on trial transcript 50. On the night of 26 November 1991, Mr. Mclaughlin testified that he was on duty at the station Number 3, that was a station that serviced Few Gardens. At 12:51 a.m., he received a phone call reporting a fire at 15 Lynn Court. Upon the arrival, 4 minutes later, Mclaughlin testified that he saw 3 black men standing outside the building, saw smoke coming from the second floor air conditioning unit. That these firemen, that men told these firemen that there were possibly children inside, which led Mr. Mclaughlin to commence rescue efforts. And that's at 54 and 55, the trial transcript. While inside, Mr. Mclaughlin found 2 bodies on a bed in front right room of the apartment, both of which were nude. The next state witness was Dr. Robert Thompson, a forensic pathologist with the state's medical examiner's office. He was tendered as an expert in forensic pathology. The court found him qualified as such, and Dr. Thompson testified that he participated in the autopsies of 2 victims, along with his colleague, Dr. Karen Chancellor, on November 27th, 1991. Based on the findings of the autopsy performed on Nishonda, Dr. Thompson testified that she died from a ligature strangulation at the time of the fire. Hemorrhages were found around her eyes. Dr. Thompson explained that that was a telltale sign of strangulation. Additionally, numerous abrasions were found around Nishonda's neck and face. Dr. Thompson conducted an examination, internal and external, vaginal and rectal areas, and found slight redness at the entrance of a vagina and a moderate number of well-preserved spermatozoa in the anal cavity. No biological was found in her mouth or in her vagina. Dr. Thompson testified that the spermatozoa had been deposited approximately 24 hours prior to Nishonda's death. Before the jury, they stated that nothing led him, in his expert opinion, to believe that the spermatozoa had been deposited at the time of death. The redness around the exterior of the vagina lacked any tearing or any other injury. That led Dr. Thompson to the conclusion that she had not been sexually assaulted. Additionally, Dr. Thompson concluded that Nishonda was not sexually assaulted, and that was both vaginally and anally. Additionally, Dr. Thompson deduced that based on the findings of Doris's autopsy, that she died prior to the time of the fire due to blunt force trauma to the abdomen. The sperm that was found in Doris's oral and anal cavities had, excuse me, okay. However, there was an internal laceration and blood-tinged fluid found inside Doris's vagina. Based on toxicology reports, it was found that she had ingested a fairly high level of toxicity of cocaine fairly recently prior to her death. The next witness was Roger Vandergraff with the Durham City Fire Marshals. He received a phone call from Few Gardens around 1 a.m. on November 27th, 1991. Approximately arriving at 2:30 was, he had testified to seeing the 2 victims being loaded into the ambulance, the fire being mostly maintained at that point. Upon entering the building to investigate, he noted that the fire originated in the left front bedroom and a pile of clothes inside the front inside on the front floor. There were no signs of an accelerant that were used. However, the fire was determined to have been purposefully set by hand. This is important because they ask a lot about gas cans or anything else, and there are a lot of different things that can be used to start fires, not necessarily an accelerant. Upon finding, investigator Vandergraff called for a homicide detective. Next, Renuka Jackson was called to the stand as the state's witness. She testified that she lived in Few Gardens during the time of Doris and Nishonda's murder. She also testified to knowing both Nishonda and Doris for 3 years prior to their death. Additionally, she stated that she knew the defendant from Few Gardens and testified that Doris and the defendant were friends who got high together and sold cocaine, which goes straight to this routing slip that they keep pertaining to, that drugs were involved. Clearly, they knew drugs were involved from all of the information that came from this case. Additionally, she testified that people would go in and out of Doris's apartment all hours of the day. All hours of the day. Well, it was known as defendant's exhibit number, I think it was 34 that was passed up. Let's see, number 34. Can you grab my... Nope. Oh, it looks like number 35. Number 35 actually was presented by the defense, and that was where D.A. Klein stated that this was a known prostitute and rape charges were never issued in the case. And that goes right to the point of this, because one of the things that all parties knew who were investigating and prosecuting and defending this case is that she was a known prostitute in Few Gardens. And so therefore, depositing of sperm in her 24 hours before this was not going to be leading to what happened without something more. And that's where linkage comes in, and that's where the state contends that they have not met their burden to show that there was any linkage between Mr. Jermac Jones and this crime. Furthermore, on the afternoon of November 26, 1991, Ms. Jackson testified that the defendant went to Doris's house in search of his girlfriend. An argument ensued. When she refused to allow the defendant into her apartment, he stated that I'm going to kill you and your daughter. At around 10 p.m., Ms. Jackson testified seeing the defendant and his brother coming from the back of the house with a television. Both men placed it into a car. Ms. Jackson then testified seeing smoke coming out of the house back then. Now, we can get into semantics and say television, VCR, or anything like that, but there are several things that are physical evidence that the defense kind of claims that there's no physical evidence in this case that ties Mr. Howard to that murder. However, there are. I mean, if we look at Marilyn Miller's testimony, she talks about pattern evidence being physical evidence. And here there was pattern evidence that there was something, some type of electronic device that was removed at some point from the top of that. And that is a different pattern from the rest of the dust and anything, and it's clear in there. And they're arguing that it's a piece from another Nintendo unit that can be seen in there. However, it is also corroborative of all of the different individuals who were investigated, who spoke with the police officers, and as Marilyn Miller said, that evidence can be very, very powerful to corroborate the witness's account of what happened. And so therefore, that VCR becomes very paramount. Not only because we've got that pattern evidence that puts him there, but what the defendant does in response to knowing about this piece of evidence. In fact, in his conversations with police, he often states that he got a VCR from this person, he got this VCR, he had this VCR. So basically he's letting them know that if you find the piece of evidence that's going to tie me even closer to this case, well, I've got a reason for that. So that could be communicated as a type of acknowledgement of guilt. And that was presented before the jury. And those are factors that the jury actually was able to see and hear. Next, we've got Rhonda Davis, who testified that she was friends for 5 or 6 years, that she knew the defendant from childhood, that she knew that Doris sold cocaine and was aware some guys from the New York boys and Miami boys sold drugs out of her house. Now, once again, that goes directly to all of the information that they had here. So here's several different pieces of this note that are in, it appears that the officers followed up with that because they were talking to the neighbors and finding out about the contents of this note. So they knew that there was the New York boys were involved somehow, that both Doris and Mr. Howard were linked up with the New York boys. And so they're going even further. The state's Ms. Davis then stated that she went back in at approximately 11 or 12:13. Ms. Davis went back to Doris's apartment to get some crack rock, and that's when she arrived there. She stated that there was a man's voice that said they were busy, and this is in the trial transcript at 199-200. She stated what heard like rattling dishes and someone going upstairs. Ms. Davis went back to her daughter's apartment and was notified at approximately 1 a.m. by Steve Cox, her daughter's friend, that Doris had been killed and the apartment had been set on fire. So this is what's known in Few Garden, which is a very close-knit area, if I know you recall, off of Kendrick Circle and Morning Glory. And that as soon as the fire went up, everybody was out there. In fact, the firefighters actually testified that all of these individuals were out there, saw the firefighters carrying out bodies of naked women, and initially they thought that the firefighters were sexually assaulting the victims. And so, of course, we've got, this sexual assault was not something that was a holdback fact. It was something that was known in Few Garden. It was known. The rumors that were flying around there could have been legion. Furthermore, they put up Terry Suggs. Terry Suggs was in the Few Garden, knew both Doris and the defendant from the neighborhood, testified for the state. He testified that Doris sold cocaine out of the apartment. He also stated that a lot of people came in and out of the apartment a lot of times. And this is important, like I said, because she's a known prostitute who sells drugs, sells other girls for drugs, and on top of it has people coming in and out of her house all of the time, according to the witnesses. So when that sperm was deposited, could have been any time within that 24 hours from any one of these individuals who were coming in and out of that apartment. She furthermore states that, he furthermore states that Mr. Suggs lives about 2 buildings down from Doris on Lynn Court. He saw smoke coming from the apartment a little after midnight. 3 to 5 minutes before seeing the smoke, he testified that he saw the defendant and a female coming through the gap between Doris's apartment and the adjacent one. The state's next witness was Kevin Best, who was also familiar with Doris, Nishonda, and the defendant from Few Garden. Mr. Best testified that around 12 a.m. on November 27th, 1991, that he was waiting at the Circle, which is Kendrick Circle, with Dwight Moody Moss, waiting for his wife, that he saw Moss, he was with Moss and saw the defendant and his brother running from the back of Doris's apartment into the apartment across the street. The defendant apparently was carrying a television, as what his brother looked like something like a VCR. About 10 minutes later, Best stated that there was smoke coming out and fire trucks arrived. The state also presented the testimony of Moss's friend, who was Mr. Best, and they kind of corroborated the same thing. Mr. Moss also testified that the defendant and Doris were arguing previously over what sounded like drugs and money. Well, that goes to this note here, that there was an argument about some drugs, and there was an argument about some money, so there's nothing new in any of these statements that were not known to either the prosecution or to the defense in this matter. Mr. Moss specifically recalled the defendant said, "You messed up my money, you messed up my drugs, and I'll kill you." That was heard by the jury. The next person, he then says about 15 minutes later, he saw smoke coming out of the back of Doris's window. Detective Doughty testified that he got a written statement from Mr. Moss later on December 5th after discovering he was outside the apartment. Mr. Moss gave Detective Doughty a statement that said about 10:30 Steve Cox was beaten up by Darryl Howard and Kenny Howard and the New York boy. So here again we've got the tie-in that Darryl Howard ran with the New York boys, that this is actually something that was known to both the defense and to the prosecution at the time. Furthermore, they stated that they were set up at Best's apartment to use drugs. He said that Steve and Doris had messed up his package. Or Steve told, furthermore, the defendant also told Steve that he and Doris had messed up his package, meaning that Steve and Doris had messed up Mr. Howard's package. Investigator Rhonda Davis then testified on behalf of the state. I think it was at page 267. He testified that he was on duty as a uniformed police officer. Also going back, a lot of those people who testified, well, they testified to seeing different things in a flash, whether he was carrying a VCR or television or something electronic, they all stated that he got into a burgundy vehicle. The investigator Davis actually pulled over the defendant on November 27th, 1991 at 6 a.m. to 6 p.m., being assigned the protection of that Washington murder scene. He actually knew the defendant, knew that the defendant shouldn't be driving, saw him in a burgundy vehicle, pulled him over, arrested him for trespassing in Few Garden, and also for driving with his license revoked. While he's processing him, the defendant just starts telling Davis that he'd been speaking with Doris the evening of her death, and that he didn't understand why she would kill her daughter and then kill herself. But he knew that Doris was angry at Nishonda for dating an older man. Next, Angela Oliver was called on behalf of the state. She was deemed a hostile witness during the trial. She testified that she used to stay in Few Gardens and that she knew the defendant. She stated that she did not know Doris. In October 1992, she was arrested for prostitution and told police that she had information and interest pertaining to the Washington murders. That was presented before the jury. Why she was arrested, how she was arrested, and the fact that she had information. After giving her statement, which was an oral statement that was tape recorded, she testified that she moved out of Durham because she was afraid of the defendant, because among other things, he told her that he would slap her. During the testimony, Ms. Oliver's recorded statement to Doughty regarding this case was played. In that statement, Ms. Oliver told Detective Doughty, "Me and Darryl went to get his drugs or his money. The lady did not have his drugs." Ms. Oliver continued that he said, "If you don't have it, I'm going to kill your motherfucking ass if you don't have my money or my packages when I get back." The defendant and Mr. Oliver went to get Harvey. When they returned, Doris still did not have the money or the drugs. The defendant pulled out a gun and started jumping on her and grabbed her and pushed her up against the wall, which is consistent with the wounds that ultimately took her life, as their own experts stated. The defendant then told Miss Oliver to go outside. Then he heard Doris hollering and screaming from inside. Miss Oliver testified that the fire was started and that they were beginning to leave, that the defendant told Howard that he had to burn him up, or burn them up, because he didn't want to leave evidence. Now, if we look at that part, all of the evidence, individuals who spoke, we've got disruption of the evidence from the fire. That was on purpose, so that he could cover up his crime. We had the nakedness of the victims, and that was purposeful, to cover up his crimes. All of this was done to cover up his crimes, and he wanted his DNA tested because he knew we would not find any. In fact, the scene was such a shamble. We had police officers everywhere. We had firefighters going up into the area. We had crowds around there, that the fact that we didn't find any other DNA is quite telling. Your Honor, she also testified via tape that bitch fucked me around, man. I had to get rid of her. Fuck her. Fuck her. Additionally, Miss Oliver mentioned that Harvey took something out of Doris's apartment, wrapped in what she thought was a sheet, later selling it on Fayetteville Street. Something. Could that have been a VCR? That's corroborative evidence, wrapped in a sheet. Could those have been the clothes of the victims themselves? Once again, these are things that the jury got to hear, the jury got to look at and evaluate. She also stated that according to Miss Oliver, Doris sold cocaine for the defendant, but Doris was a user and had been messing up his packages, and which upset the defendant. I think it would upset anybody. Miss Oliver testified that she told the truth in the statement to Detective Doughty. Then we next have Milton Smith, fire marshal with the Durham City Police, that testified the investigating the fire at Lynn Court. Arriving upon the scene, the fire marshal spoke with investigator Graaff about the state of the victims and a rescue effort. Investigator Graaff informed the fire marshal that if the fire was started in the fire was started in a pile of clothing in the upstairs bedroom closet, and that no sources of ignition were found. According to investigator Graaff's comments to the fire marshal Smith, the fire appeared to be set by human hand, an arson. It was not until Miss Oliver gave her statement on October 12th, 1992, that arrest warrants were issued for the defendant and Harvey. Upon hearing of the arrests, fire marshal testified that he did go to the magistrate's office to complete booking sheets for the defendant and Harvey, and that while the fire marshal was collecting information from Harvey, the defendant approached the fire marshal and said that his brother Kenny, not Wiz, was with him at Few Gardens when the fire occurred. And this is at page 318 through 320 in the trial transcript. Fire Marshal Smith then asked the defendant, so it was your brother Kenneth was with you when this thing went down, or when you did this thing, to which the defendant said, yeah, it was me and Kenny. And this is at page 320 in the trial transcript. Despite this information, he proceeded to book Harvey. Fire Marshal Smith then testified that the defendant came right over his shoulder and said, "You're a smart motherfucker, ain't you?" The next witness was Gwendolyn Taylor, who testified. She was actually identified in the discovery as Gwendolyn Roper. She was actually found as a tip that came in blind, kind of like these other tips. There were many tips that were actually in the discovery, some of which the officers were able to go down and find the actual witnesses, and some that they were not. This witness was able to be found. She came forward and she testified that she saw the defendant at the liquor house sometime before November 27th, 1991 and December 31st, 1991. At the liquor house, Ms. Taylor testified that she heard the defendant making comments about Washington. Specifically stated that she heard the defendant say, "Yes, I killed that bitch. The next one who get in my way, I'll mess them up too," in response to if someone asked if he killed Doris. The next person who testified was Eric Campen, the crime scene technician. He testified that he was assigned to investigate the Washington murder. He stated that he spoke with the investigator Graaff and began his investigation. He noted that the television console had appeared to be pulled away from the wall, and on top of the television there was a dust patch indicating something was missing, and a crack pipe was also found. The state's witness, Detective Darryl Howard, Doughty, then took the stand, stated that he was assigned to the murder investigation on or around 2:30 in the morning on November 27th, 1991. And through his investigation, Detective Doughty found Nishonda had run away with her boyfriend almost a week before the murder. So that was known in the discovery and to the defense and to the jury. He also obtained Mrs. Roper's statement regarding the comments at the liquor house, and thought that he had enough to arrest the Washingtons. He felt that he had enough, but he wanted a little bit more. He chose to investigate for a full year longer until he was more comfortable with his decision to charge in this case. So not only did they take time to make sure that they got it right, they investigated another year before they arrested him. The defense presented two witnesses, Ms. Mayo, the defendant, and himself. However, before the defense's case began, the court conducted an in-camera review of the Department of Social Services records. Those records were reviewed by Mr. Woody Van and by the prosecution and by the judge. They were deemed not sufficient to go forward into the trial. They were deemed, we don't know exactly what was in there, because those I'm sure have been destroyed, and I believe that they're different than the records that we got in our cases. However, those memos and that work product and that DSS record was something that was known to the defense at that time. In fact, some of that report was actually in the newspaper and stated that the Nishonda was afraid to go home because she was hit with a belt and a broomstick, and that was because their drug deals with her mom were going bad. There were also, Natasha Mayo stated that her longtime girlfriend, or that she was the longtime girlfriend and mother of the defendant's son. She testified in his defense. She testified growing up with the defendant and knowing both Doris and Nishonda through the defendant. During the testimony, she admitted that the defendant sold drugs for a living, and many people were scared to death of the defendant with good reason. The defendant was a cocaine user, and according to Ms. Mayo, would use cocaine with Doris at Doris's apartment. Ms. Mayo also testified that being at Doris's apartment a day or two before the fire, and that the defendant coming to get her, the defendant was mad at Mrs. Mayo for being at Doris's apartment because Doris kept a lot of company, and it was men in and out, and she would try to talk to me about getting something else from one of them other guys. Mayo went on to clarify that Doris would try to get her to do sexual things with men in exchange for drugs. Mayo testified that she never witnessed the defendant speak in a threatening manner to Doris or Nishonda, and those things were put before the jury. She also stated that they stayed in the house for the rest of the night on the 27th, and the same evening, Junebug and another man brought over a television and VCR to Sharon's apartment. That was heard by the jury. Mrs. Mayo testified that Detective Doughty came to collect her statements on 2 separate occasions. The first occasion, he told her that her fingerprints were found inside. Mayo explained that she and Doris used drug together in the presence, so her fingerprints made sense. Ms. Mayo testified that Detective Doughty then presented 3 warrants, 2 for murder and 1 for arson, and told Mayo's mother that he was not sure if Mrs. Mayo would be coming home. For the second meeting, Ms. Mayo testified that Detective Doughty drove her by the magistrate's office before bringing her home, where he confided in her that he was deathly afraid of the defendant. That was in the trial, that was in the defense notes that they have received. That was knowledge that everybody had. Okay. On November 20, Ms. Mayo also testified that the defendant was together at Sharon's house. She testified that the defendant was selling drugs out of the apartment around midnight, and Ms. Mayo stated that the defendant were, that Ms. Mayo and the defendant were around the apartment, went to Doris's apartment to get cocaine from the New York boy apartment, which she shared with Doris. Your Honor, she also the defendant then testified on his own behalf that he had been trespassed from Few Gardens because he was a former drug dealer. He admitted to being both cocaine and a heroin addict. In November of 1991, he testified that he was not selling drugs, but mostly running errands for other drug dealers. Your Honor, however, the discovery and everything that was in the possession of the defense showed that he was actually picked up on that same day of the homicide with drugs at Sharon's house. However, when he was dealing drugs, the defendant denied ever selling for the New York boys or for the Miami boys. The defendant testified that he knew Doris and he would see her all the time because he would help look for her daughter when she ran away and needed to be picked up. According to the defendant's testimony, Doris was a fellow drug user, sold cocaine for the New York boys out of her apartment. 2 days before the fire, the defendant testified that he was going to Doris to retrieve Mrs. Mayo because Doris had a habit of using other women to get her own drugs. He went on to clarify that she would ask women to do sexual things with men in order to get drugs. The defendant did not want Ms. Mayo to get involved in Doris's business of trading sex for drugs, and he told Doris such. On the night of Doris and Nishonda's deaths, the defendant testified that he and Kenny and Mayo were staying over at Sharon's apartment getting high. Around 12:30 to 1, Sharon sent the defendant and Mayo to get drugs. And he stated that that was in the same apartment building as Doris. He stated that they went outside waiting for drugs, and the defendant testified to seeing smoke coming out of Doris's window. Mr. Suggs said his friends ran in the building to try to help. And so the defendant and Miss Mayo decided to run back to Sharon's apartment to avoid being arrested for trespassing. The defendant testified that he was unaware of Doris and Nishonda's death until someone came over and announced what had happened at 4 or 5. Later that morning, the defendant admitted to being arrested for driving in a Few Gardens. The evidence presented before the jury was based on the evidence. The defendant was found guilty of second-degree murder and arson, and on the 31st of March, 1995, the Honorable James Spencer sentenced the defendant to 2 consecutive 40-year terms. Pursuant to obtaining the convictions for the charges, the state dismissed 2 charges of habitual felony conspiracy, and felony conspiracy to traffic in opium and heroin on April 3rd. Your Honor, furthermore, this case went to the Court of Appeals, where they looked at and evaluated a lot of the actions that were taken by the police department that have been argued here, and they were found to be proper. So the only question before us is it relevant, and is it material, and is it favorable? And I submit to you that if you look at all the evidence, all of the paperwork in this case, all of the files, you will not see one name. You will not see Jermac Jones. And that's not because he didn't do anything. I'm sure that he had sex with somebody. He may have sex with Doris and doesn't want to talk about it. He may have had sex with a few other people. They could have had a huge orgy at the house, but none of them were responsible for the death of Doris Washington based on the evidence that was presented before the jury, presented before the court, and found credible, and relevant, and proper. Your Honor, once again, favorability under 15A 269, an evidentiary hearing can be conducted to determine the favorability of the DNA. However, the statute does not define what favorability is. The standard, however, we can look to State versus Norman. That's 202 North Carolina App 239 331, and that's a 2010 case. In that case, 2 counts of kidnapping were charged to Mr. Norman, as well as 2 counts of sexual offense and crimes against nature. DNA testing was granted in that case. The DNA analysis showed that there was sperm mixture of 2 or more individuals, neither excluded nor included the defendant. Instead, gave a broad list of probabilities that sperm came from several different ethnicities. The court in that case ruled that this was not favorable because it does not exclude the defendant as a perpetrator in this matter. Therefore, one could look at the State versus Norman case, which I'm going to pass over to counsel and to Your Honor. This is oh, sorry. So therefore, we can kind of interpret that a favorability result would be taken into account the underlying crime, looking at whether the new DNA results would exclude the defendant as a perpetrator. And I would state that to the court respectfully, the overwhelming evidence in this case are not overdone by this finding of Jermac Jones' sperm. We don't know when it was deposited, we don't know how it was deposited, but what we do know is that this case, many, many people came and stated a lot of different things, and they presented that to the trial, they presented that to the jury, and that was that, let's take a look at this, break this down. The informant advised that they probably murdered, so we don't, this in and of itself denotes that he doesn't have any first-hand knowledge. Murdered the mother because he owed money. Well, that came out. That Mr. Howard was very angry with Ms. Doris Washington for not having the money. stated that it was either a Philadelphia or New York boy. Well, the case file, the trial transcript showed that he was very much with the New York boys. Whether he was part of them, running errands for them, is still part of the New York boys. The other residents were offered a couple $1,000s a week for the use of their apartments. Obviously that's true because Doris had the drugs there. 4 bags of drugs were left in the apartment. Apparently it came up short. That's possible. Nobody ever said that they found any drugs, but they did say that they found a crack pipe. And the perp said that the victims were possibly raped and strangled. That was known to the individuals in the Kew Gardens because they were there that morning. They saw the naked bodies of the victims. So where this evidence or this information comes and how the defense attempts to bootstrap this to the importance of the DNA can't overcome the surmounting evidence in this case. Your Honor, I would just respectfully state that the defense has not met the burden in this case, but once again, you are the trier of fact.
All right, Ms. Ellis, I will agree with you on at least one thing, and it was mentioned by Mr. Scheck also, and that is that Mr. Roger Eccles and his staff, whom you know is the elected district attorney of Durham County, I agree with you that he doesn't have a dog in this fight. And I think that his staff, which includes you, and Mr. Morrow, who's been in this case for a long time, I can remember to this day him bringing me that order to sign to do the DNA testing. He's been here a long time. And unlike the irony that Mr. Scheck mentioned of 2 disbarred lead prosecutors having something to say about what happened in this case, I think Mr. Eccles' staff, which includes you and the people who work on this case, have been nothing but professional. And it's very difficult to do these kind of hearings. You've been involved with a motion for appropriate relief that took us a lot of time and effort to get through and to coordinate a lot of things. And Dr. Miller, forensic scientist, talked about what you can do and what you can't do because of the system we work in is an adversary system, and you all are adversaries. These hearings can get very contentious, but I think all of you have done an excellent job of being professional. Now, that being said, I disagree with just about everything else that you argued today. And I do intend to find that the defendant has proven the existence of new DNA evidence favorable to the defendant that shows his innocence. The court does intend to find that new DNA evidence generated by post-conviction DNA testing was favorable to the defendant. Defense counsel is going to propose an order to the court based on the required findings of 15A 270. The court will show that that evidence presented to a reasonable juror would find beyond a reasonable doubt that there is a reasonable doubt as to the guilt of Darryl Howard in these cases, the court will vacate these criminal convictions. The court will discharge Mr. Howard from custody. The court will order a new trial in these cases. And I'm sure that Mr. Cooney and Mr. Scheck will travel on to other cases and do what they do with the Innocence Project and on their own. But somewhere in there, they're going to give me an order. And that order is going to release this defendant from custody. I don't know how we're going to do it, but I don't see any reason why he can't be released today. Can you tell me why he can't be released today, Mr. Scheck?
I see no reason, Your Honor.
Okay.
In fact, I think that previously we had argued a bond conditions, and I think we have an order drafted.
Well, Ms. Ellis is standing. That means she wants to be heard. So,
Thank you.
yes, Ms. Ellis.
Your Honor, respectfully, we do give oral notice of appeal.
Yeah, that is an interesting part because we talked about that, I don't know, what, months ago? About what the state would do if we got to this point. And Mr. Cooney has argued that you don't have a right to appeal. I know you were talking to the Attorney General's office about that, and apparently maybe because it's an election year that Attorney General probably changed your mind, because I thought at one point you and Mr. Morrow thought that maybe you didn't have a right to appeal. So maybe that issue has never been litigated. Well, it has been litigated in some aspects. So tell me about the right to appeal.
Your Honor, the only thing that I know is that there was a recent case that came down talking about what the Court of Appeals had a right to hear and what they didn't have a hear. From what I understand, if they're actually divested of jurisdiction, that's when they can't hear it by statute. But nothing actually divests them from hearing this matter. And I believe that that's what, the rest of that is out of my hands. That's with the AG's office.
Yeah, out of my hands too. Yes.
Well, I was just going to point out that the case is actually stating it's Norman, which she handed up to the court. This is because Your Honor has ordered a new trial. This is an interlocutory appeal. It's not an appeal from a final termination. And as an interlocutory appeal, the state has to have a specific jurisdictional grant in order to appeal. And State against Norman pointed out that when the General Assembly passed this, they didn't enact a right of appeal from a decision on favorability. They did for a decision denying DNA testing, but they didn't for a decision on favorability, and therefore barred a defendant from appealing in State against Norman a decision that DNA evidence was not favorable. And we, we've always assumed that street's going to run both ways in terms of not having a specific jurisdictional grant for the appeal of an interlocutory order. It might be different under some of the rules if you had dismissed the charges. Then under those circumstances, under Rule 2 of the appellate rules, and in the interest of justice, the courts would have supervision over that final termination. But since there's not a final termination, there has to be a specific statutory grant for an interlocutory appeal. And that's the law as I stand here today.
All right. Well, back to my original question. Where does that put us right now?
Well, I think right now where that puts us is, first of all, we'd like to have Mr. Howard discharged. Your Honor held a bond hearing back in July of 2014. Heard the state, heard us. The only thing that's changed since 2014 is this man's gotten 2 years older. And if it's Your Honor's wish that he be discharged without conditions, or perhaps on an unsecured condition to appear, then we certainly think that's appropriate. As you'll recall, the evidence was in 1995 he was out on bond and showed up every day to his trial. So we don't believe he's a flight risk, and we believe that discharge would be appropriate now and today. And we are prepared, if the state is serious about this notice of appeal on the DNA, and we're prepared to move forward on the motion for appropriate relief. We are hopeful the state wouldn't notice an appeal if we prevail on the DNA, in which case we wouldn't have to hear the motion for appropriate relief. But in light of the fact that they apparently indicate they're going to appeal, then we have no choice but to go forward on the second motion. So we would request prior to doing that that the court enter an order discharging him from custody without condition.
And the court will do so. Okay, first of all, it's lunchtime. It does happen.
And we will be prepared to start with our first witness after lunch on the motion for appropriate relief, assuming nothing develops in the meantime.
All right, is the state going to be prepared?
Absolutely, Your Honor.
All right. First of all, Mr. McDougal. I'm sorry to hear about your father. Mr. McDougal lost his father. 2:30, Mr. Chair.
Motion recess till 2:30.